Yes, sir.
All right, I appreciate that. Thank you.
I want to tap the screen.
I know. I want to ask Brandon to bang the wall so that, you know, on the other side of the wall.
He's laughing about that.
Yeah.
But why can't he hear us?
I don't know.
Can he see us? Like this?
Yeah.
He's not
He's
looking.
not looking anyway. I'm waving at Mr. Rizzo. Mr. Rizzo, unmute. Unmute. I'm making a clicking motion with my hand here. Oh, wait. Oh, we had it for a second there.
There he is. Now you got
I
it.
can't hear you. I can't hear you. He's not saying anything.
Here
He's
I
a
am.
man of few words.
Okay.
All right, there you are. Okay. I don't know what's going on with this, but now I didn't think maybe Mr. Almeida I can't hear. Can you hear me, Mr. Almeida?
Yeah, I can hear you, Judge.
Okay. And Mr. Rizzo, one last check to see that you're there?
Yes, I am.
Okay. There's like a little lock thing. I don't know. We'll get used to this. All right, we're going to proceed with the Antonio Sweat case, W 2020, 52-311. Mr. Sweat has his first appearance earlier today. State has filed a motion for his pretrial detention. May I have your appearances, please?
Good afternoon, Assistant Prosecutor Brandon Almeida for the state.
Anthony Rizzo,
Thank you.
appearing on behalf of the defendant, Your Honor.
Thank you. And Mr. Sweat is here. Mr. Prosecutor, you ready, sir?
Yes, Your Honor. The state's ready to proceed.
Mr. Rizzo, you ready?
Yes, I am.
All right, very good. What do you have, Mr. Prosecutor?
Thank you, Your Honor. To begin, the state would ask the court to mark for identification state's exhibits S1 through S4, with S1 being the public safety assessment, S2 warrant 2020-520311, S3 the affidavit of cause, and S4 the defendant's criminal history.
Mr. Rizzo, any objection to S1, 2, 3, and 4, which have been marked for identification?
No, Your Honor, thank you.
All right, thank you. S1, 2, 3, and 4 are in evidence without objection. Anything further, Mr. Prosecutor?
Yes, Your Honor, thank you. With respect to probable cause, the state relies on the affidavit of PC admitted into evidence as S3. With respect to detention, the state first notes the public safety assessment scores. Mr. Sweat has nearly the maximum score possible. He scores a 6 and a 5, and there is a new violent criminal activity flag. Additionally, at the time of this offense, this defendant was on probation. Taking this into account, the recommendation of pretrial services is no release. In the incident matter, this defendant has one charge, disorderly persons offense of simple assault. These are a disturbing series of facts that led to this charge, Judge. There was a physical altercation between the defendant and his intimate partner. The victim reported that the defendant came to her house because she confronted him regarding Facebook messages to another female. In response, the defendant hit and slapped the victim and then proceeded to pour bleach on her after dumping trash out on her bed. So, Judge, what's concerning is
Well, pour bleach on her or pour bleach on her clothing?
on her clothing. Presumably, it was, I've seen photos. It was clothing that she was wearing, Judge. So presumably,
okay.
Yeah, presumably she was wearing the clothing when he poured it on her. And so what's concerning is it's not just the physical slap, but this defendant took actions to exercise dominion and control over this victim, because I actually believe he also took her phone and broke it when she tried to call the police. So it's not, in addition to just the physical hitting, there's concerning facts here that show this defendant exerted control over this victim. Looking at the personal characteristics of this defendant, this is someone with ongoing domestic violence issues. He's had DV issues with multiple women. He also has CDS abuse issues, as demonstrated by his prior conduct. He has CDS charges from 2008 through the present, and DV issues starting back in 2007 through the present. At the time of this offense, this defendant had 3 pending charges, all from last month. They're all CDS related, including possession with intent to distribute CDS and possession with intent to distribute in a school zone. This defendant has 3 prior disorderly persons convictions. Most recently and most significantly, a simple assault from October of 2019. That involved a different female, Your Honor. The facts of that case are that the defendant strangled the former intimate partner until she lost consciousness. And what's interesting is the conviction was in October of 2019, but the offense date stems from 2018. And it's, I believe, and it was charged as a B13. And I believe that's before the legislature modified that to be what is now a 3rd-degree crime. It was only charged as a disorderly person's DV strangulation back then. But that's particularly concerning in light of the current charges. So with respect to the factors for detention, first, for failure to appear, this defendant scores a 6 out of 6. He has 5 total failures to appear, including 2 within 2 years, 1 as recently as February 18th of 2020. This defendant poses a moderate risk of obstructing the criminal justice process based on the nature of this offense, being this victim was a domestic violence victim who was a former intimate partner of the defendant. So this isn't some random victim. This is someone who he's intimately familiar with. However, the state's focus here, of course, is the danger to the community and to this victim. First, this defendant scores out 5 out of 6 for new criminal activity. And of course, there is a new violent criminal activity flag indicating the elevated risk of violence. This defendant is someone with a history of domestic violence involving multiple women and also has demonstrated he's got ongoing CDS abuse issues as recently as last month, who recently just got arrested and is on probation and continues to commit violent crimes. As touched on, he's not amenable to release because he's on probation and has had 2 arrests within a month and a half, first for possession with intent to distribute and now for the domestic violence incident. And of course, that's just further evidence of his ongoing CDS abuse and domestic violence issues. This defendant also has had the benefit of both PTI and a conditional discharge, as noted on his CCH. And again, he's had the benefit of diversionary treatment, but instead continues to engage in criminal conduct. And this judge is someone who's not deterred, as based on his prior context with the justice system, his recent arrests. In February, 11 total arrests, 4 of which are domestic violence related, 2 active restraining orders, a 3rd now. This is somebody who's demonstrated that if released, he'll continue posing a threat to this victim and to all other members of the community, Judge. And for these reasons, we're asking that you follow the recommendation of the public safety assessment and detain Mr. Sweat.
Question for you, Mr. Almeida.
Sure.
The victim has children. Are any of the children his children?
Not, my understanding is that they are with a different individual, Judge.
And were any of the children, although maybe not his, present at the time of the incident?
I'm not aware one way or the other of that, Your Honor.
Okay. Thank you, sir. Mr. Rizzo.
Thank you, Your Honor. Your Honor, I would like to put this in context, even though the incident itself is upsetting standing by itself. But putting it in context, what we see is that he didn't threaten her with a gun or a knife or baseball bat, such as we saw somebody earlier today was guilty of. He didn't seek her out. He didn't encounter her. I'm not suggesting that she's to blame for going over there. Obviously, his actions, if true, aren't justified by the fact that she came to him. But the point is, if there was a no contact order put in effect today, I think that it would keep him away from her so that this type of incident wouldn't repeat itself. What I'd like to suggest, Your Honor, is that he's charged here with a domestic violence, what appears to be a simple assault. He's got pending charges over in Mercer County involving 3rd and 4th degree charges, I believe, as the prosecutor indicated, drug charges. So what I'm suggesting, Your Honor, is that we put him on 3+ monitoring here and allow Mercer County to bring him over there, to house him there and deal with his charges there, and perhaps wind up with a consolidated sentencing resolving both the cases there as well as the case here.
All right, thank you. Any response from the state?
One brief point in response, Your Honor. I may have misheard Mr. Rizzo just due to the technical nature of what we're doing now, but I thought I heard him say that the defendant did not actively go out and seek this victim. And if so, I would just like to push back on that. The affidavit of PC makes clear that when the victim confronted this defendant about messages on Facebook, he came to her house, which led to this altercation. And I'd like to respectfully point out that that's suggested this was more than something just done in the heat of passion. He made the purposeful, conscious decision to seek her out and go to her house. So this is something he premeditated, that he thought about. This wasn't something that they got in the argument in person and proceeded to have some sort of physical altercation. And that suggests a higher risk of danger to this victim.
Oh, I called him about it and he came to my house. Okay. Thank you. Any final words, Mr. Rizzo?
No, Your Honor.
Okay. All right, thank you. This is the pretrial detention motion for Mr. Antonio Sweat. The state has filed a motion for his pretrial detention, and we've had the hearing. First of all, the court finds that the state has established probable cause for this offense based on Exhibit S3, which includes a preliminary law enforcement incident report. It's concise, well-written, detailed, and gives the court a very clear picture of what occurred. The court absolutely has a well-grounded suspicion that the offense was committed, and we know that probable cause calls for far less evidence than is needed to convict at trial. We didn't try the case today. At trial, the standard is proof beyond a reasonable doubt. The court also finds by clear and convincing evidence that there's no amount of monetary bail, non-monetary conditions, or combination of bail and conditions that would reasonably assure this defendant's appearance in court when required, and or the protection of the safety of any other person or the community. That's the primary concern. And or that the defendant would not obstruct or attempt to obstruct the criminal justice process. The court is satisfied the state has established its burden by clear and convincing evidence, because after considering all of the evidence and all of the other things presented here, the need to detain this individual was so clear, direct, and weighted and convincing as to enable the court to come to a clear conviction without hesitancy as to the truth of the facts at issue. The court makes that decision for a number of reasons, including the nature and circumstances of the offenses charged. This is domestic violence assault. This is someone who's committed these types of acts before and who's been punished for this before, yet here we have another domestic violence assault. The particular circumstances are that he injured the victim, he slapped and hit her, he also poured bleach on her clothes, he broke her cell phone, and he tried to create a mess of her and her children's possessions. Very disturbing incident, something that took place over some course of time, some course of conduct had to take place for this to occur. This is not a 2-second and done incident where somebody says something or they're arguing and then that person gets hit, which is a terrible thing in and of itself. But this was a series of offenses committed against this victim. The weight of the evidence against the defendant, considering the admissibility of any evidence sought to be excluded, appears to be very strong. It includes the personal observations of the law enforcement officers who investigated, statements of witnesses, including the victim. Also, there's a 911 call for help, or at least reporting it. There's also physical evidence, all the disruption in the apartment, the mess made in the apartment, the bleach damaged clothes, the broken cell phone, the victim's swollen mouth, and the victim's abrasion around her left eye. The history and characteristics of this defendant is also a worry for the court. His criminal history begins at age 19. Right out of the gate, he has 1 pre-TI, and he has 2 conditional discharge. You're only supposed to have 1 conditional discharge. Somehow he got 2. So he's had 3 diversionary programs, yet he continues to commit offenses. He continues to hurt people. He continues to be dangerous in the community. And as far as domestic violence, this is his 5th domestic violence arrest. 5th one. Criminal history is reflected in the public safety assessment in S4, and does not have a good record concerning appearance at court proceedings, is also reflected in the public safety assessment. At the time of the offense, he was on probation. This is very significant. CAPS ID S00-33590. And what was he on probation for? For domestic violence assault. Originally charged as an aggravated assault, downgraded to simple assault, 1 year probation, and here we are, November, December, January, February, less than 5 months later, a domestic violence assault charge while he's on probation. So we don't have to guess. Is this person going to comply with pretrial conditions? Is he going to leave victims alone? Is he going to be dangerous? Yes, we know that because he has violated his conditions of probation, and he has done these things before. So that leads us to the biggest concern. He absolutely is a danger to any intimate partner, one from October 2018, now this one from March 2020. And his rage and offenses against her were provoked by the victim accusing him of infidelity. And he went to her apartment to confront her. And really, people say, you're cheating on me all the time, or I saw you with another woman, or I saw you with another man on Facebook. You don't go over to somebody's apartment and beat him up. You are to do things other than that, but this is an individual that resorts to violence. By the way, one of the things you can do is tell them, you know what? Yeah, I'm moving on with our relationship. I'm going to go out with the person you saw me on Facebook. See you later. And a lot of people do that. What? Yeah, it's okay. The court is also concerned to a lesser extent with the nature and seriousness of the risks of obstructing or attempting to obstruct the criminal justice process that would be posed by the defendant's release if applicable. There is a potential for witness intimidation of the domestic violence victim intimate partner. The release recommendation, the pretrial services program obtained using a risk assessment instrument is that release is not recommended. The scores are almost maxed to 6 and 5 scores, and there is a new violent criminal activity flag for elevated risk of violence.
Can I speak, please? Can I speak,
As you stand, no, sir, please don't say anything. As you stand before the court, we know that Mr. Sweat is on 1-year probation, imposed recently in October for simple assault. Started with the strangulation, became amended to simple assault. He has 3 pending charges from February 4th, 2020. That's not that long ago. And they're for indictable drug charges, including distribution.
I live in my truck.
Sir, Mr. Sweat, please don't interrupt. And if you interrupt, I'll have you removed.
I'm sorry. I'm sorry, Your Honor. I'm
Please don't
sorry.
interrupt. He has 3 disorderly person convictions. 2 are drug-related, and 1 is domestic violence assault. He has 4 total failures to appear, including a recent one from February 18, 2020, for those CDS charges from 14 days prior. Domestic violence history, he has 1 active final restraining order from November 27, 2018. And really, what is disturbing, and also he appears to have unabated substance abuse issues. But really, cutting to the real core of the matter, what is disturbing here, and which impacts on his level of dangerousness to this victim and others is the following. And I have A, B, C, D, and F, 6 things. 1, A, he struck her and injured her. B, he poured bleach on her clothes, and that's a red flag of an attempt to dominate someone, because when you damage a women's clothing, that puts her in a subjective position. It is a threat to her femininity, and it is a threat to her appearance, which is very important. So that's a big red flag. C, he broke her phone. So she couldn't call the police, therefore isolating her. That's another red flag. D, he disregarded her personal space by pouring trash on her bed. E, he threw around her children's possessions. That's another way of expressing dominion and control. Basically, please remove Mr. Sweat. Please remove Mr. Sweat. He was warned.
I apologize, Your Honor.
No. Please remove Mr. Sweat. Mr. Sweat, you're excused. Please go back to the jail.
I'm sorry.
And this is an indication that after being told that he must be quiet. Sometimes the court says the wrong thing, and maybe there's a way to deal with that in a peaceful way. But no, he immediately reacts. That impacts on his level of dangerousness. The court is concerned that in a setting where he's not in jail with officers, with a judge talking to him, instead with a domestic partner that he's going to try to intimidate and control, she'll say something that he doesn't like, and then she's in real danger because he's going to lash out at her. He just is not a guy who has any self-control. And you know, the shame of it is that he's 35 years old. You know, he's not we get a lot of immature 18, 19, 20-year-olds, and eventually they grow up, but this guy is still very volatile and very much unable to control his emotions and therefore his actions. So throwing around children's possessions, I was saying, is also, and they're not his kids either, is also a way to show this victim, look, you can't do anything to stop me. I will mess up your kids' clothes or your kids' possessions. I'll throw trash on your bed. I'll pour bleach on your clothes. I'll break your phone. And all of this is an attempt to isolate, subjugate, control this victim. And these are all domestic violence red flags. This is a dangerous person. And why did this all happen? Because she told him she suspected him of cheating on her. And that's really a small provocation for these extreme, elaborate acts. It's just really, it's a very troubling situation, and his record of domestic violence is not a not a good one. This is not an isolated incident for this guy, and he's on probation for domestic violence. That he got a break when it was downgraded. Not a good situation at all. The state is more than satisfied its burden. The court will direct the defendant to be afforded reasonable opportunity for private consultation with counsel. So now that he's detained, he does have a right to appeal this order within 7 days pursuant to Court Rule 2:9-13. Thank you, gentlemen. We have to go to first appearances. We do not have a lengthy list. Are you handling first appearances, Mr. Rizzo?
Yeah, Mr. Spiro is going to handle them, Your Honor. I believe he's
Okay.
accessible right now. Let me log off and I'll go get him in.
Okay, thank you, Mr. Rizzo, but you're going to come back. Oh, no, you're not. You're done. You're done. Last case is with Mr. Corby.
Oh, that's right. Is that Mr. Wagner?
Okay, I see Miss Gran, I see the jail, and I see a booth that may be in Salem County. It's a nice-looking booth.
Salem County, and you also have ACJ.
Oh, okay, we have ACJ there.
There's Salem County.
Okay,
This is Atlantic County Jail at the bench warrant.
okay.
This is a violation of probation. Mr. Dorfner is supposed to be coming up.
Violation of probation?
You already held him, and they want his bail reduced to OR, so his public defender, so.
Oh, he can stay on camera. He's cute, Catherine.
Who's that?
One of the exceptions.
One of our sergeants here.
One of the sergeants.
He was just curious what all the action was.
So the gentleman.
What was the bail, what's the prior record on this?
Oh, look at your dog.
Lester?
Oh,
Oh,
they're gonna argue in front of you, yeah.
Well, I need the prior memo on that, so I see what.
Oh, you already said that? Oh, it's the last page. You already asked to be held without bail. They're gonna talk about his VOP, yeah.
he's held pending his VOP, which is April 15th.
Oh, okay, all right. It wasn't like he missed multiple court appearances.
Yeah, you already did that, yeah. They're trying to get an OR bail.
Okay, thank you, Chris.
I put the three motions to reopen. They're at the bottom of that. I printed the three motions.
Okay.
I don't know if you have them or not.
Good, thank you very much, very good.
You're awesome, Krista.
That's why they keep me around.
Yeah.
Julian is the baby
It's
bear.
not,
I have to see
it's not
her.
just your charming good looks, right? Yeah,
There's a lot more.
there's a lot more to the whole picture, yes. Okay, all right, we'll get to work here. This is first appearances for March 20th, 2020. Thanks for being early, ACJ. Helps us a big deal. Hi, what is your name, please?
Xenia McKinney.
Hi, this is a bench warrant for Xenia McKinney, 19-2327001. We'll execute the bench warrant. And ma'am, you are in the Atlantic County Jail. There was a bench warrant that was issued on September 18th, 2019 for failure to appear at a pretrial conference. Would you first... What's that? Pre-indictment conference. Yeah, that's what was written. I got it wrong. Thank you. All right, ma'am, would you please tell me what your address is?
545 Newton Lake Drive, apartment C309, Collinswood, 08107.
All right, let me go over that with you. 545 what drive?
Newton Lake. It's all one word. Newton Lake Drive. Newton Lake. Yes, Drive.
Okay. Apartment C309, Collinswood, New Jersey, 08107.
107.
Okay. Yeah, what's your phone number, please?
856-580-2715.
Okay. And you've been in Atlantic County Jail for how long?
I've been locked up since February 22nd. February 2nd.
Well, I wish someday they'll fix those microphones. We have trouble with the sound quality. Can't give me the answer again. I'm sorry I keep asking the same things over and over again. It's not your fault. But
February 2nd.
you know what you do? Lean back. It's actually better if you lean back. Lean back. Okay, there you go. All right. Since Since March
I was
17th?
no, I was incarcerated since February 17th because I was in Camden waiting for Atlantic County to pick me up as of the 20th.
Oh, okay.
So
Now, how long have you been living at that place in apartment in Collingswood?
Like 2 months. What happened was I didn't appear because I just lost my son January 29th. He was 8 years old. So he was sick since July 5th. So I was in CHOP Hospital since July 5th, and I pulled the plug January 29th. So my son was sick for 7.5 months.
Oh, I'm so sorry. That's so sad. All right. Well, you missed the court date you missed. Let me explain what it is that you missed. You missed a pre-indictment conference, You're charged with a shoplifting offense, which is a third-degree offense. And that court date that you missed on September 18th is a court date that is designed to see if you can resolve the case. And so that is not repeated because what has happened to your case is that it's now going to the grand jury for possible indictment. So the prosecutor is reviewing it to present it to the grand jury. So eventually, if you are indicted, what will happen is that you're going to get a notice to come to court for a post-indictment arraignment, and you'd have to come to court here at the Burlington County Courthouse. Are you with me so far?
Okay, yes, that's 49 Rancocas Road, right?
You got it. Yes, very good. All right, now here's the thing. What's that?
No, now I hear you.
Okay. Here's the thing. I don't have a new court date for you because who knows when it's going to go before the grand jury. They got lots and lots of cases. They have hundreds of cases that they have to deal with. So yours is one of them. So sometime in the future, you're going to have a court date. In the meantime, I accept your explanation for not appearing in court. I don't want to hold you without a court date, so I'm going to release you on your own recognizance, but you need to come to court, okay?
Okay, yes.
Okay. Do you have any questions, Ms. McKinney?
No.
No? Okay. Please make sure you come to court so you don't get yourself jammed up in jail in the future, okay?
Okay.
All right. Good luck to you.
Thank you,
Thank you,
Your Honor. Have a
ACJ.
good weekend.
All right, you too. Thanks for being early. It was really helpful. All right, now we're going to try Salem. Okay. Hello, sir. You have a special situation here?
No, I'm trying to find out. You had one guy left on your detention list. Means?
Yeah. Means. Yeah, we're going to get to that after first appearances. We'll slide right into it.
Okay, because I already had him on. All right, let me get the other guys in then.
Okay. All right. Shouldn't take too long. We're going to slide over to Salem County if we can. Yeah, look, here we go. We got Salem. All right. Ready, Salem?
Hello.
Okay. I think we have Salem County. Are you Mr. Thomas Wallace?
Yes, sir, I am.
Okay, Mr. Wallace, this is case number 18-0530-001. This is a bench warrant case. We'll execute the bench warrant. This was issued on February 14th, 2020 for failing to appear at sentencing. This was your second bench warrant. You were previously released on a summons. The sentencing that you missed is rescheduled with Judge Haynes on April 23rd, 2020. And why did you miss the sentencing, sir?
I was in physical therapy. Are you there, sir?
Yeah, I'm here. Physical therapy?
I lost you. I'm sorry. I was in physical therapy for, I have compartment syndrome. I got hit by a car. I was in an accident. In doing so, I have complacement syndrome in my leg, which my leg swelled up. They had to cut me open and drain it. So I was in Maple Shade physical therapy.
All right. Was that inpatient?
It was inpatient. Yes, it was.
Really? Where in Maple Shade did they have inpatient physical therapy?
It was, I believe it's Meadowview.
Meadowview, yeah. Did you call anybody and say, hey, listen, I'm going to miss my court date, and I can't make it because I'm in physical therapy?
I was understanding. I have a private attorney. I was understanding that he was taking care of that for me.
Oh, who's your private attorney?
Stephen Altamiro.
And how long have you been in the Salem County Jail?
I've been in Salem County since Sunday. Excuse me, the 15th.
Have you spoken to Mr. Altamiro to tell him what your predicament is?
I had no clue I had this warrant until a little while ago. Yesterday, actually. I spoke to. I tried to get a hold of.
Have you spoken to Mr. Altamiro? So you didn't even know. So you missed sentencing. You didn't even know you had a warrant. Is that right?
Didn't even know I had a warrant for it, sir. I didn't know I had it.
Were you worried? Were you worried that your bail, $3,500, was going to be revoked and forfeited?
I didn't know I missed it. I didn't know I missed it at all. I didn't know.
That's not my question. My question is, were you worried that your bail, $3,500, was going to be revoked and forfeited? No,
I didn't know. No.
Okay. Yeah. Well, looks like.
I would have been.
So, sir, thanks for your answers. It appears very certain to me that you really are avoiding a jail sentence in which you're facing 18 months recommended by a plea agreement.
It's 15 months, and I'm not.
And I don't believe that you at all thought that your attorney was quote unquote taking care of it. You had some skin in the game, or somebody had some involvement by posting the bail, which was forfeited. This was your second bench warrant.
Your Honor, I was ROR.
Appears to be no conditions of release that would ensure your appearance at sentencing. You'll get credit for time served. I'm going to have you held without bail, and your next court date is April 23rd, when Judge Haynes will have the sentencing hearing. All right, good luck with Judge Haynes, sir. Thank you, Salem County.
Thank you, Your Honor. Jesus Christ.
Now we go to BCJ. And we have BCJ there. All right, good afternoon, everybody. Today is March 20th, 2020. These are first appearances. It's all being done by video court. I have the prosecutor here, and I have the public defender here. Can I ask for the prosecutor to enter her appearance, his or her appearance, please?
Thank you. Assistant Prosecutor Kathleen Mears-Graham on this matter.
Thank you. And I don't have the public defender here. Okay. Michael Devine, please come forward. Michael Devine. Mr. Devine, this is a new case, W 2020 46-316. In your case, Mr. Devine, the prosecutor has filed a motion for your pretrial detention. So your first appearance and your detention hearing are scheduled for this Tuesday, March 24th at 9 o'clock. So what will happen on Tuesday at 9 o'clock is that I'll see you again in the assembly room. I'll go over your rights as a defendant. We'll talk about the pretrial detention hearing that's scheduled for that day. And then at some point after that, we will have your detention hearing. You understand that, Mr. Devine?
Yes.
All right. Any questions?
No, Your Honor.
All right. Thank you, Mr. Devine. We will see you on Tuesday. Okay. Let's now have Andre Laster come forward. 18-3907002, 19-07330002, and 19-07910001. Who is handling this case from the prosecutor's office?
I will be, Your Honor. Ms. Brown.
All right. Do we need defense counsel, or is this quick and easy?
We are not consenting to his release. We are
okay. So I need to have.
VLP hearing.
Okay. And the VLP hearing is on April 15th. I guess I need defense counsel on this, right? All right. So, Mr. Laster, we'll wait for the attorney to show up on the screen here. If you would have a seat, sir, I appreciate it. I don't have the attorney here yet. So I'll come back to you, Mr. Laster. Let's now have the case of Matthew Pierce, 20-05810001. I don't have any paperwork, but I shouldn't need any paperwork. Fair enough? Okay. For Matthew Pierce, 20-05810001, Ms. Grant, is this also your matter?
I think Mr. Harris is going to handle this one.
Would you enter your appearance, Mr. Harris, sir? Yes, sir. Do you know what town this is out of? If you have the warrant number.
It's out of Edgewater Park Township, if I may.
Okay, thank you. All right, Mr. Pierce. Did you hear all that? You originally were charged with a third-degree domestic violence matter. The prosecutor has downgraded the case. It's now a disorderly persons case. It's no longer an indictable case. You are therefore released with the understanding that you're to attend court in Edgewater Park. Now, have you been on release conditions? I'm sorry, there are no conditions. You were detained. Sir, you are ordered to go to court, and you're to be very, very careful with any contact with the victim. You understand that?
Yes.
All right. Do you have any questions?
No, sir.
What's that? No. I mean, is the state seeking a release on any PML level? No? Okay. All right. I can ROR with no contact. Okay. Mr. Pierce? You're recommending? Okay. Okay, yeah, I think that's what we need to do. All right, back to you, Mr. Pierce. You know that you need to come to court, correct, sir?
Yes. Yes.
Okay. They'll give you, Edgewater Park will give you a court date. The courts are closed for a while here, so you need to stay in touch. You're not to have any contact with the victim. Are you married to the victim?
No.
Do you have children with the victim?
No.
Were you living with the victim?
Yes.
All right, well, you have to live somewhere else. You're ordered not to have contact, meaning not in person, not by phone, not by letters, texts, notes, anything on the internet, no email, no social media. Where will you be living, sir?
My mother's address, 91 Blackwood Clementon Road, Clementon, New Jersey, 08021.
91 Blackwood Clementon Road, Clementon, New Jersey, 08021. Is there an apartment number there at 91?
Yes, apartment 117.
Apartment 117. What apartment complex is that out there, sir?
Birchwood Apartments.
Birchwood, okay. Do you have children? You don't have children with this person, right?
No.
All right, so it should be less complicated. Sir, you're not to possess firearms?
Sir, I've been logged in for minutes, for about an hour, because I thought it was at 1:30. I'm watching and seeing everything. I'm logged in. I see my SPER, and I can neither talk nor be seen, so I am lost.
Okay. Well, let me get through this, Mr. Sparrow. I'm almost done with Mr. Pierce, who's getting released. Mr. Pierce.
Yes. Well, it's a tablet hooked up to a. It looks like a tablet hooked up to a, but there's no tower. So I would, whatever a tablet is.
All right, Mr. Pierce. We're having little technical problems here, but I want to make sure you get all these things.
I had to go to a different office. I'm a per diem guy. I don't even have on my computer. I don't have a tablet.
All right, Mr. Pierce, sir. You're on monitoring level 1. You have to make one phone call once a month to pretrial services. You're not to have contact with the victim.
Yeah, you tell me about it.
You're to attend all court appearances. You're also ordered to notify pretrial services if your address changes or your phone number changes. You call in one time, once a month, every month. Sir, do you have a firearms purchaser's ID card?
No, sir.
Do you, well, if you don't know what it is, then you probably don't have one. It allows you to purchase weapons. You're not to possess any firearms, destructive devices, or dangerous weapons. You understand that, sir?
Yes.
Okay. And you're to attend all court appearances. Any questions, Mr. Pierce?
No, sir.
All right. I think you can do this, but you need, if you need to get things out of the apartment in Edgewater Park, you need to contact Edgewater Park Police to get an escort there so you can get your things out of there. And also, if she contacts you because for whatever reason, she misses you or she wants money, you are not to return the contact to her. Is that clear, sir?
Yes, sir.
Okay. Any other questions, sir?
No.
Okay. Good luck, Mr. Pierce. Let's next have Tashawn Hawkins, 20-03940001. Mr. Hawkins.
Hi.
Mr. Harris, you have input on this one? Okay, do we know what town the shoplifting is from? Morristown? Okay. Mr. Hawkins, your case was an indictable shoplifting charge. It's been downgraded to disorderly persons level charge, so it's no longer an indictable charge heard up here at the county. You understand that, Mr. Hawkins?
Yes, sir.
All right. So you are released. You need to go to court in Morristown. Do you know where the Morristown court is held, sir?
Yeah, I know where it was. I know where it's held. I was there. It's like by the precinct, right?
Well, which town? It's not in Morristown. There's a hint there. Where is it?
Oh, I don't know. Where?
Well, yeah, don't look at the other guys for help here. I'm going to tell you, we're not playing a quiz game, but you told me you knew where it was, but actually, I don't think you do know where it is. So let's make sure you know where it is, so there's no excuses. They have their court in Cinnaminson. It's on Riverton Road. It's just across Route 130 if you're coming from Morristown. It's by the library. There's also in the same neighborhood, there's a Sonic there. Are you familiar with what I'm talking about, sir?
Not really, sir, no.
All right, well, you better find it, sir. No excuse that you don't know where it's at, because everybody else knows where it is, including people that are standing behind you. So you better go to court when they tell you. What is your current address going to be, Mr. Hawkins?
1100 Atlantic Avenue, apartment B1, Asbury Park, New Jersey, 07712.
Okay, what is the first part of that address, sir?
1100 Atlantic.
1100.
Like the ocean.
That's PD. That's P.
Okay.
Avenue,
you got that?
apartment B1,
Okay.
Asbury Park, New Jersey, zip code 07712.
All right, thank you, Mr. Hawkins. If you miss court in Morristown, which is actually in Cinnaminson, a warrant will be issued for your arrest. All right, good luck to you, sir.
Thank you.
All right, do I have the public defender there now? I know Mr. Sparrow was making efforts to public defender's office.
Hello.
The only matters I have left involve the public defender, involves Mr. Laster, Mr. Fury, Mr. Anderson, and Mr. Crean.
I don't know if he can hear you, but he's here.
Where?
He's gone. You see how on the bottom it says BCJ Assembly and Brandon? And
Yeah.
it said Spiro.
Did it really?
And it keeps going away. Charles is working with them.
Okay. All right, just stand by, everybody. Officer, if you want to move some of the people along, I just need Mr. Laster, Mr. Fury, Mr. Anderson, and Mr. Crean to stand by.
We'll take you guys back.
I'll keep my cursor there. I can jump in when you need to.
What's that? Yeah.
You must be dying up there. This
Yeah.
Fan,
I see that.
but George saw me fan and then he went this.
So Julian's working from home today?
You think?
Yeah, I was gonna say, you know.
I want to see it. Where is the? Oh, look at the boo.
Yeah.
Okay.
Julian, he or she's gorgeous.
Is that like an enclosed porch? Sunroom, yeah, nice. I was talking about backgrounds, backgrounds for the judge, beach, Taj Mahal. I'm out visiting, I'm out on vacation. Another one is in space, outer space.
Yeah.
And then I thought of another one, which is I'm working under a car. I have tools. I'm taking my transmission out. Yeah, all kinds of backdrops.
You got lots gonna be working from home?
It's optional right now. I'll be here if I can. They'll let us in. Yeah.
Did you see, you can dial up and, I think through Facebook, and have the astronauts on the space station read bedtime stories to your kids? I think it's kind of cool.
And we spent how many billions of dollars to get them up there, and they're reading bedtime stories?
A police officer in New Hampshire was doing it as well.
It's like Mayor LaGuardia used to do, right?
Uh-oh, we lost Julian. He might be done though.
She's doing, Mr. Grant, is it Grant?
Ron?
There he is.
She's doing it. Oh, there you go. I think that case was actually Mr. Laster. I think.
You are correct.
I thought Mr. Blumen was doing that, Mr. Laster, but.
See, on the bottom, it says Office of the PD Spiro.
Oh, I
I
thought it
don't
was
know if you can hear
Prosper.
us.
Mr. Sparrow, can you hear us?
Yes.
All right. Who's clapping? I didn't see them clap, though. Okay, that's weird. All right, Mr. Sparrow, are you with us?
I am, Judge.
Okay, let's go through the reopened detention matters. We have motions on Martin Fury. Martin Fury, would you come up, please? Case number 19-4556001. Martin Fury. May I have your appearances on these detention reopens? First from the public defender.
Good afternoon, Your Honor. Eric Spiro, by way of video, audio, on behalf of Mr. Fury.
Thank you. And who's the prosecutor? Okay, thank you, Mr. Harris. Mr. Sparrow, you made a motion to reopen detention. Is that correct, sir?
Well, one of the other, Jared Dorfman, actually, it's his application, but I'm covering it for him because he's working at home today, Judge. I have the file with me, though, and I've reviewed it.
Okay. Is there a consent to this, Mr. Harris? No. Okay. Okay. What is it? Are you ready to argue this, Mr. Sparrow, at this point?
I am, Judge. The matter appears to be relatively straightforward. There is a charge of aggravated assault, third degree, in possession of CDS, which I don't believe is the sticking point. It appears that on February 27th of this year, an alleged victim provided a statement to an investigator at this office in which the alleged victim, Crystal Reinhart, claims, or rather denied, that Mr. Fury had actually grabbed her by the neck and choked her. Mr. Fury apparently, according to Ms. Reinhart, grabbed her by the shoulders, or grabbed her by one shoulder, and expressed that, quote, he loved her, end quote. She insists at no point during their public argument did she ever feel that her safety was threatened, and she stated that the information reported to the police by one of the bystanders, apparently there was a bystander statement, was in her characterization blown out of proportion. It also appears that she intends to, although I don't have any information that she actually has, approach the prosecutor's office to file the appropriate paperwork to drop or withdraw the charges. Mr. Fury is detained. Obviously, he's not able to see the court for some time. Fact of the matter is, if this plays out in the way it is, and it appears court was canceled all this weekend, will be all of next week, which is going to cause a backlog. Matters getting scheduled are going to be scheduled further out, possibly facing on days when it's very busy. Cancellation on those days. Given the fact that there is new information here that the purported victim seems to be recanting, which isn't, I will concede, an uncommon matter, but it is one that I believe is relevant, especially since she's the complaining witness, and the only other evidence of file at this initial stage seems to be a hearsay statement from a bystander who's not identified. It would seem that her recantation or her intention to do so materially changes the matter, and I believe it's a situation where Mr. Fury, I believe, can be, well, the matter should be reopened because of this new information. I believe it would allow for him to be to be released, we would consent to any level of release, 1, 2, or even 3, just so long as he is released. And the other factor, of course, is this business with the COVID-19 cases. It's appearing that the news reflects that more and more cases of this are actually coming to light in a close facility. That's no criticism of BCJ, but it is a bit, the sanitary standards perhaps aren't as high as others. It's closed quarters. There are new people coming in all the time. It seems a dangerous situation to be there. Certainly, any of the criminal justice reforms, keeping people in a sort of unsafe situation like that's inconsistent with the nature and spirit of the criminal justice reforms. So, given all of this, we would submit that the matter can be reopened, should be reopened, and Mr. Fury should be released on some level of monitoring. And we'll even consent to level 3 monitoring, just so long as the matter can be resolved in his favor and he can be released today.
Mr. Sparrow, do you have the original public safety assessment, the complaint warrant, the affidavit of probable cause, and the order from the court in support of your motion?
I believe Mr. Dorfman filed that along with the motion. The information that I have, I do have the complaint, and it tracks with the information that was provided with respect to a bystander statement, but I don't have the PSA. I'm not sure what his scores were, but I note this is the only open case it appears that he has, but I don't know, honestly, candidly, Judge, I don't know what the numbers were. I don't.
All right. All right. I mean, do you have that information, Mr. Harris? All right. And before you elaborate, because there's no way I can decide this without the underlying information. I mean, all I have in front of me besides proffer, and I'm sure that you'll recollect correctly, and then Mr. Sparrow, I'm sure everything he says, always says and has said today has been accurate, but I needed more information. I was under the assumption, and I guess this is what happens when you assume things, that these were all consents like we did, I don't know, yesterday or the day before. We did like 6 in about 10 minutes, and they were all consents. And it's fine. I'm not suggesting that you should consent, but I need to have the underlying information in order to make an informed and proper decision on this case. Let me just put that aside for a second. Are there consents on the other two, on Anderson and Crean? Okay.
That's accurate, Judge. I have the same information.
Okay, but not Anderson. Anderson is contested? Okay. I'm going to have, I don't know if we're going to be able to do this today. I'm going to have to get the underlying information and review it like I did with all of these motions. And it's not you know, a 2-minute and we're out kind of thing. It's not an automatic thing. And obviously, if it's contested, the court has to consider arguments of counsel plus what has happened to the case so far. So I'm going to ask Mr. Fury to have a seat. We may or may not get to your rest of your case today. We have some other things on the schedule, but we'll see what we can do. I need to get that underlying information, and once I have the complaint warrant, the probable cause statement, the court's order, and the original public safety assessment, I can proceed with this matter. Same applies to Mr. Anderson. Is there someone from the prosecutor's office that can handle the Daniel Crean matter? All right, Mr. Daniel Crean, this appears to be consent. Can you come forward, sir? This is a Daniel Crean case, 20-0457001. Motion's been filed. Mr. Sparrow is appearing on behalf of the defendant. Mr. Dorfman filed the motion, and the prosecutor is Julian Harris. Mr. Harris, you consent to the motion, sir? Okay. And is there any recommended monitoring level? Yeah. Well, actually, the guidance I have on that is that pretrial services will tell the defendants what they need to do and that may vary over the course of time. But right now, I think they're doing telephone, and then we'll see what happens. So I don't want to just say from now on telephone, and then that changes. I'll just advise Mr. Crean to just do what pretrial services says in terms of reporting as the situation evolves. Mr. Sparrow, anything further? There's a consent to monitoring level 3.
No, that's acceptable, Your Honor, and the fact that there's an accommodation to make it telephonic, I think increases the likelihood of compliance since it's easier than an in-person appearance.
All right, thank you, Mr. Sparrow.
Yes, sir.
Mr. Crean, with the consent of the prosecutor, sir, you are released on monitoring level 3. You need to follow conditions of monitoring. If you don't do this, the prosecutor can file a motion to revoke your release. Monitoring level 3 requires weekly reporting to pretrial services. You'll be given a phone number to call. You call pretrial services, do that first thing on Monday, and you should be instructed what you'll do. What you have to do may change, but basically you have a weekly reporting requirement. You understand that, Mr. Crean?
Yes, sir.
Okay. Mr. Crean, you are to not have contact with the victim. The victim is your mother. This has happened before. You are to not call her. You are not to text her. You're not to go to her house. You're not to see her in person anywhere. You're not to write her letters or notes. You're not to have anything delivered to her house. You are not to go do anything on the internet, email, or social media. No contact whatsoever. Is that clear, Mr. Crean?
Yes, sir.
Okay, and if she contacts you for some reason, you're not to respond. Sir, you are to attend all court appearances. Your case has been downgraded. You'll get a court notice. You are also required to notify pretrial services if your address changes. What will your address be, Mr. Crean?
222 Jackson Road, Medford, New Jersey, 08055.
All right, thank you, sir. And your phone number, please.
609, I can't remember it off the top of my head, I don't think. I'll give you the house number where I'll be at 609-922-4464.
Okay. Okay. Give me your address again, sir, so we can write it down.
222 Jackson Road, Medford, 08055.
08055, Jackson Road, Medford. Okay, thank you, sir. Mr. Crean, you're also not to possess firearms, destructive devices, or dangerous weapons. You understand that, sir?
Yes.
Okay. Any questions, Mr. Crean?
No, sir.
Anything further, Mr. Sparrow, Mr. Harris?
No, Your Honor.
All right, thank you. Good luck, Mr. Crean. Please be careful. Do not have contact with the victim.
All right.
All right. Let's now slide over to Andre Laster. Andre Laster, 19-3907002. I'm sorry. Start again. 18-3907002, 19-07330002, and 19-07910001. I don't have any paper. Yes, I do have paperwork. Mr. Laster is held for violation of probation. The violation of probation hearing is now scheduled for April 15th, 2020 at 1:30 with Judge Morley. And Mr. Sparrow, I believe the state is, I believe defense is requesting a release on this violation of probation matter. Is that correct, Mr. Sparrow?
Correct, Judge.
Okay, and it's Eric Sparrow for defense and Kathleen Grahn for the state. It's my understanding this is not consented to. So since it's your motion, Mr. Sparrow, I'll hear what you have to say.
Well, again, Your Honor, I am somewhat disadvantaged that I don't have the information, specifically the PSA or the detention order. These weren't
right,
included
but
in
can I just interrupt you, Mr. Sparrow?
Yes,
this
sir.
One's a little different from the Fury and Anderson cases because Mr. Laster was held on a violation of probation matter. So normally we don't have a detention hearing. He was out there and essentially got arrested on an outstanding warrant or outstanding warrants for violating probation.
Right.
And so you wouldn't necessarily see a public safety assessment.
Right, but I mean, with respect to the underlying, because I know he's on monitoring, so that presents an issue. But I think what's relevant here is there is actually what Mr. Dorfman characterizes as a technical violation. It doesn't appear that the violation is an an issue or matter generated from the obtaining or new charges, which is usually more significant and more serious because it's additional lawlessness on top of the allegations that have already been provided. Such being the case, and given the fact that matters have been pushed off for some distance, it's certain, and Your Honor indicated April 15th is the next court appearance on the violation of probation. That's nearly a month from now. Usually these matters are more expeditiously resolved, but I think because of the backlog caused by the court closures, and the fact that it just doesn't appear the violation of probation is going to result in his I don't know necessarily that he's going to be violated for this and a new sentence imposed. It seems, again, a technical violation with respect to, I believe, reporting issues. It would seem that the continued detention of this individual just for a technical violation on the VOP is unnecessary, especially and also in consideration of, besides the delay, which is unnecessary and seems a bit long, is the fact with his potential exposure to the unsanitary conditions, the overcrowded conditions, the new persons coming into the close confines of the Burlington County Jail. It seems to militate in favor of his release pending the new court date of which Your Honor indicated. I don't have that in front of me, but I believe Your Honor's April 15th for the VOP.
That is the correct date, sir.
Thank you, Judge.
1:30, April 15th. Okay. Any response, Ms. Cron?
Yes, Your Honor. Mr. Laster's been held since February 27th, as you know, on these pending violation matters. We are asking that he continuously be held pending the new violation of probation hearing date. He was sentenced in June of 2019 to two conditions of probation. He's completely and utterly failed to cooperate with any of them, having by July 5th, after his June 19th sentencing from last year, already moved and not been in touch with the probation department. So his mother had reported to probation, according to the violation summary, that he was no longer living there. He made no contact with the probation department, failed to keep in contact with them, as well as failed to comply with the substance abuse evaluation, which was the whole point of putting him on probation. So at this point, we are strongly opposed to releasing him. We have strong reason to believe he would not appear for court in the future if not continuously held. We ask that he be held pending that violation date on April 15th, Your Honor.
I have a couple questions. Since being placed on probation, have there been any new offenses?
I'm not aware
Charged?
of any, Your Honor.
Mother lived where, and mother lived in what town? Ms. Ron, did you know?
The address he had been providing, which I assume is his mother's, was in Mount Holly. That's what's on
Okay.
his pre-sentence report.
And where did he go to when he was arrested?
That I do not know.
Okay.
I gave them.
And do you know how he got arrested or how he got to the attention of the police department?
I just have him that he had his first appearance on this VOP February 27th. I'm not sure how he came into the court.
All right. Mr. Sparrow, any response to any of those items made, any of those points?
Well, again, Your Honor, obviously, if a substance abuse evaluation was supposed to have been done and was not, that's obviously perhaps a bit more substantial. Although this isn't something that can't be quickly and in very reasonable amount of time rectified. My guess would be he could probably have a substance evaluation completed weekly. All the way up to the next court date in April 15th. It would seem that one matter and the fact that he forgot to tell probation that he moved, which is another issue that's got this causing problems for the VOP. Again, a bit technical. What's relevant, I don't think there's any new charges. It shows that he's at least taken that part of seriously, and lamentably so many others. It's not the standard by which it should be measured, but I think it's worth or merits consideration that he hasn't picked up new charges as many others do on a VOP. Failure to get the substance abuse evaluation done. A condition of his release could be that he needs to get it done within 10 days, or he does stay in the county jail. That's certainly a decent or a reasonable amount of time, at least in which to schedule it. It may be that get him in there within 10 days is a bit trickier, but if he doesn't have proof of that within 10 days provided to his probation officer, then I would submit that that's sort of, it incentivizes him strongly. to get this sorted out. I would say less time, but since today's Friday, I don't know that he could effort getting one scheduled over the weekend, and that would just leave him a few short days next week. And facilities may have truncated hours because of the situation with the health issues in the public domain. So I would submit if we release him and give him those 10 days to at least get something scheduled, failing that and proof of it to his probation officer, then he's really been given and passed on his final opportunity to do that. As far as changing addresses, that seems like if that was the only thing, that wouldn't have gotten him into the hot water that he's in now.
All right, the court records that have just been printed for me show that on the older case, 18-3907002, that Mr. Laster already missed a violation of probation hearing on September 18th, 2019. It also, we know that he's been in jail since, on this case, since, as the prosecutor said, February 27th, 2020. What's that? On all three. Okay, on all three. The state has given information also that is very concerning to the court, which is that the whole reason for probation, or the main reason for probation, or what was driving it, is that Mr. Laster needs a substance abuse evaluation, which he did not have. It's good to hear that he's willing to do it now, but that just seems like a justification for trying to prevail on the hearing and get released more than anything else. Certainly, Mr. Laster has had plenty of time since July to get a substance abuse evaluation, and it creates an inference that Mr. Laster is still involved with and or using controlled substances, illegal narcotics, or non-prescription drugs. And the other problem is that there's been no contact since within a month after he was released in July. So it's more than just changing address. He really absconded, and it's been what are we looking? 8 months since he's been accounted for, and we have 3 separate cases. So it just gets to be overwhelming. The court is going to respectfully deny the motion. Mr. Laster is someone who the court is confident would not appear when he's supposed to, and also would not have the ability to comply with substance abuse directives or treatment. Oh, sir, please don't say anything at this point. No, sir. No, we're doing this by proffer. Mr. Laster, I said, no, we're doing this by proffer. Okay, so the court is going to deny the motion, and Mr. Laster will be held until the hearing on April 15, 2020 at 1:30. Maybe it's possible that there can be a
I've never gotten a chance.
Scheduling, and I already asked Mr. Laster not to speak. And what does that show us? No, I keep those. What does that show us? It shows us that Mr. Laster doesn't do what he's asked to do, even by a judge.
I'm sorry.
All right, Mr. Laster is excused, officer. If you can take him back, please.
That's the thing, man. I got family dying at home. Y'all don't care.
Not sure what he said, but I don't think it was something very good. The record reflects that Mr. Laster is very disappointed, is expressing his frustration and disappointment, inappropriately so, and it further reinforces the court's decision. All right, that leaves us with Fury and Anderson. I don't have the information that I need. I'll direct either counsel or somebody to get me the original PSA, the complaint warrant, the probable cause statement, and the court's prior order, so I can properly have that information in front of me for the hearing. We're going to postpone the Fury and Anderson cases till Monday, and we'll do this. What's that? Okay, well, I don't have them now, so we'll adjourn this till Monday. Time to be established by people scheduling this. And we'll
So
handle
which two cases for Monday, Judge?
The 2 cases are Fury and Anderson.
Thank you.
All right, thank you. Gentlemen, we'll take your cases tomorrow. Monday, next business.
Mr. Harris.
Thank you, sir.
Hold on, buddy. Hey, hold on. Wait till Mr. Green gets back. You sit right there.
Your Honor, I believe that concludes our first appearances.
And thank you, Mr. Harris. Appreciate it, Mr. Sparrow. Thank you, sir. We're going to go to the Michael Devine case. And you're ready to do this one, Mr. Almeida?
Which case, Judge?
And I said the wrong case, not Michael Devine. Sorry about that, guys. We're going to go to the Jerron Means case.
Yes, I'm ready on that, Judge.
Yes.
Is my lawyer present? Is my lawyer present?
All right, Mr. Means, can you hear me?
Now I can, Your Honor.
Okay. Your attorney is on the phone. I know that you're standing. If you're more comfortable or if you get tired, please feel free to sit down. I don't want there to be any physical issues or problems because you thought you had to stand the whole time. Is that clear, sir?
Yes, Your Honor.
All right, thank you. This is the matter of Jerron Means, W 2020-71-320 and W 2020-78-320. Mr. Means has had his first appearance on both matters. They are related. They have the same promised gavel number of 20-939-002. This was postponed by Mr. Corby from March 18th to today. May I have your appearances, please, Mr. Prosecutor?
Good afternoon, Assistant Prosecutor Brandon Almeida for the state.
Mr. Corby?
Corby on behalf of Karen Means.
All right. Are you ready at this point, Mr. Corby?
Yes, I am, Judge.
Okay. Mr. Prosecutor, you ready, sir?
Yes, I am, Your Honor.
Okay, go ahead, sir.
Thank you, Judge. To begin, the state would ask the court to mark for identification with regard to S1 through S6, with S1 being the PSA, S2 warrant 2020-71-0320, S3 the affidavit of probable cause for that warrant, S4 warrant 2020-78-0320, S5 the affidavit of probable cause for that warrant, and S6 the defendant's criminal history.
Mr. Corby, S1, 2, 3, 4, 5, and 6. Any objection?
No objection, Your Honor.
All right, S1, 2, 3, 4, 5, and 6 are admitted in evidence without objection. And I have all of these here. S5, S6. Okay, I need a couple minutes to go through these things, so bear with me.
What did they just enter into, piece over there for me?
Huh?
You got a piece over there for me?
Okay,
You got a piece over there for me?
okay. No, man. Yeah, she does. If you want. I don't know if people are standing there.
Of course, the last boxes I would take it out. They ain't gonna get out. They're gonna take this box. Like, come on. And then if you would. I know,
And he wasn't, he said that he don't want to do it.
Bless you. My daughter goes into the Navy Monday. My daughter goes into the Navy on Monday.
All right, Mr. Prosecutor.
Thank you, Your Honor. First, with respect to probable cause, the state relies on the two respective affidavits of PC admitted into evidence before the court. With respect to detention, first the state notes the PSA scores. The state notes the defense scores like 6 to appear, 5 for new criminal activity. Taking these into account, the recommendation of the pretrial services is no release. Now, Judge, before getting into the merits further, I do want to point one thing out. These charges stem from a search that was completed on a motor vehicle And during the search of that vehicle, police ultimately paused, got a search warrant, and proceeded to further search the vehicle. So there were two sets of charges, but they really stem from one criminal incident. Looking at the PSA, there are approximately 11 charges listed under pending charges under Promise Gavel number 2929, which are really charges from the underlying motor vehicle stop. So they should be counted under the current charges, not under the pending charges. So in fairness to Mr. Means, it does not appear as if he has actually the total, like the 13 pending charges at the time of the offense. He really only had 2. However, I'd like to also point out that looking at the top of the PSA did not appear to take the repeated arrests while on release into account when making its recommendation. Instead, it makes its recommendation of no release based on the defendant's elevated risk score. So with that said, in the current matter, as
Mr. Almeida?
Yes.
Excuse me 1 second. The PSA I have here, it's in S1 in evidence, is 11 current charges. Is that what you have?
I have one that shows 3 current charges. I have a PSA dated March 17th, 2020.
Yeah, this is March 12th.
Okay.
So that has all the charges as current.
Are there? Is the score still 6 and 5 though, Judge?
Yes. Actually, it doesn't. This one does not include the
second set of
it's
charges.
It's still 6 and 5. It doesn't include 78. The 78 charges.
Yeah. So as those charges were, that complaint was cut this past Monday, the 16th, after they executed the search warrant.
All right. So I need that one. Can you print that out, Connie? All right, we're going to print that out. We'll come back to that, okay?
Okay. Do you want me to continue that or wait for that, Judge?
Would you please continue?
Sure.
Go ahead.
So, Judge, as alluded to, from the 2 warrants, there are a total of 14 charges in this matter, several second-degree weapons offenses for the 2 handguns that were found in the vehicle during the search, and 2 possession with intent to distribute charges, as well as other CDS offenses. As alluded to, these stem from an underlying motor vehicle stop. The defendant was the driver, and there were 3 other occupants in the vehicle. Upon stopping the vehicle, the officer immediately detects the odor of marijuana, finds that the driver, the defendant, had an active warrant, placed him under arrest, removed all occupants from the vehicle, and proceeded to search the vehicle. That search led to the discovery of 205 grams of marijuana, 9.9 grams of cocaine, and additional pills. Additionally, during that search, officers found a loaded handgun with large capacity magazines in the center console of the vehicle, at which time they stopped, obtained a search warrant, and proceeded to search the vehicle. And during the search warrant execution, police found an additional loaded handgun in the rear, under the rear passenger seat, and a gravity knife in the front passenger door. Looking at this defendant, his personal characteristics, this is a convicted drug dealer who continues to deal drugs. And what the state would submit, there is evidence of escalation now, because this defendant was never charged with any gun or weapons offenses before. And now we have somebody who's continuing to deal drugs, but this time, of course, with 2 loaded guns and a crew in the car. At the time this offense is touched on, there were actually only 2 pending charges prior to the underlying motor vehicle stop, 2 counts of operating a motor vehicle during a second or subsequent period of license suspension from July 2019 and from September 2018. This defendant has a total of 7 prior indictable convictions, 6 of which were CDS related, including 2 possession with intent to distribute charges and 1 other resisting arrest prior indictable conviction. With respect to the 3 factors for detention, first, this defendant poses a high risk of failing to appear. This defendant scores a 6 out of 6 on the PSA. He has a total of 5 prior failures to appear, including 2 within 2 years, most recently January 6th of 2020. Next, with respect to his risk of obstructing the justice process, the state also submits there's a high risk. This is based on the numerous aliases and social security numbers noted on the CCH. First, just in New Jersey, there are 4 different names noted on a CCH, including Robert Hollins, Darnell Adams, Darnell Jones, and Jerron Means. And additionally, there are 2 different social security numbers listed for New Jersey. Then, he also has a New York history. there are the 4 aliases listed, plus an additional one of Lamine Adams. So between New Jersey and New York, there are a total of 5 different aliases for Mr. Means. Additionally, on the New York CCH, there were 4 different date of births listed and 3 different social security numbers listed. So Mr. Means, by his conduct, has shown that he'll give a false name, he'll give a false date of birth, he'll give a false social security number in an effort to evade police detection. Additionally, the state admits that his prior indictable resisting arrest conviction further shows his risk of obstructing the justice process. Last and most concerning is this defendant's danger to the community. The state admits there's a high risk, first based off his score of 5 out of 6 for new criminal activity on the PSA. Looking at this defendant, Judge, this is someone who's, as mentioned, he's a convicted drug dealer, and now he's riding around with a crew. He's got 3 other people in a vehicle with multiple loaded guns and a significant quantity of CDS in the car at the time. And actually, Judge, while we were doing detention hearings this morning, I received an email from Detective Brian Martino, the detective who executed the search warrant in this case, and they also conducted a forensic examination on Mr. Means' phone. And they uncovered several concerning text messages on the phone. First, on the day of the car stop on the 11th, Mr. Means texted a passenger in the car, the co-defendant.
Judge, I would object to this.
Hold on.
In the out-of-state criminal history, I have not been provided a copy of anything.
Judge, all right.
The text messages that the prosecutor is trying to admit to evidence, and the criminal history for out-of-state. I have no copies of that at all in my discovery.
All right, I'll stop you there, Mr. Almeida. I know the normal rules of evidence don't apply. We do this by proffer, but you don't need to go there. Just stick with what's in the documents provided, okay?
Okay, Judge. It's my understanding that the out-of-state CCH was included in the discovery, which I gave to Mr. Corby in person yesterday.
It's included it is an exhibit. Look at the end of S6, Mr. Corby. It'll say page 1 of 6, and then you'll have page 1 of 3, and then you have 3 pages and 3 more pages. So a total of 12 pages, and actually maybe another one. 1 of 1. A total of 13 pages in the exhibit that I have, sir. You have 13?
Yeah, I have a criminal history from New Jersey, but I don't see anything after that.
Okay.
That's all I have.
Is that only 6 pages long? Or?
I think so, yeah, it's about that, yeah. Yeah.
Well,
it's criminal history from New Jersey.
Right, that's what it starts with, but how long is the document you have?
Hold on a second. Let me see. Hold on a second, Judge. I got it. I have two sets of discovery. One I printed out from B courts and one I was received yesterday. Just want to make sure they jive.
And so with this, we have to make sure.
Excuse me, is there any way that I can privately speak with my attorney?
Unfortunately, not by this way, sir, because he's on a phone, you're on a TV screen, and that's one of the limitations of what we're doing.
Yeah, Judge, and yesterday I tried to make plans to see my client via video, and no one answered the phone at the jail to set up that appointment. So I didn't have communication with him.
That's regrettable.
I did speak to him on Wednesday. I have 6. Yeah, 6 pages.
6 pages.
of criminal history.
That's it. All right, let's move on, Mr. Almeida, okay?
Sure, Judge. So in any event, Judge, as I said, this is a convicted drug dealer driving around with a crew with loaded guns, which demonstrates his danger to the community. He's demonstrated he's not amenable to pretrial release conditions. Looking at his CCH, he has 4 prior violations of probation noted in New Jersey. So this is someone who's had numerous chances on probation and failed 4 separate times, demonstrating if released on conditions, we know what he's going to do. Additionally, Judge, look at his, the state would direct the court's attention to his 2 pending charges for driving while suspended for a second or subsequent violation. This shows, again, repeated conduct. This is someone who's under an order not to drive and who continues to engage in the same behavior, which is just another example that he cannot be controlled with conditions. Judge, this is someone who's demonstrated he's not deterred by his prior conduct in the justice system, as demonstrated by his 7 prior indictable convictions, 11 New Jersey arrests, 2 New York arrests, a total of 5 sentences of incarceration. And now he's not just reoffending, but he's engaging in the same behavior, dealing drugs. And again, here, as I said earlier, there's escalation as evidenced by guns, the presence of loaded guns, which weren't there before. Judge, for these reasons, the state's asking that you file the recommendation of pretrial services and detain Mr. Means.
Thank you, Mr. Almeida. Mr. Corby.
Yes, Judge. As you know, under this charge, my client enjoys the presumption of relief. He was charged with 4 other individuals in the car. The car was not registered to him. Nothing, if I stand corrected, was found on his person, either guns or drugs.
Can I ask you real quick, Mr. Corby, was he the driver of the car?
Yes, he was.
And were the other, I know the other man in the car was charged, were either of the women charged?
I don't believe so, and I don't know what plans Maple Shade Police Department has for them.
Okay.
I just know that the co-defendant, Ramik, well, it was released by Your Honor on Wednesday.
Okay, there you go.
He's
All
the
right.
co-defendant.
Okay, thank you. Go ahead, sir.
I believe he's charged with the identical charges that my client's charged with.
Okay.
He had 2 pending charges, Judge, at the time of the offense. He was not on probation, was not on pretrial release for those 2 charges, they being, even though they're 4th-degree traffic offenses of 2C4026. He was charged on summons from those 2 towns, Evesham and Maple Shade, with those 2 charges. They're pending in front of Judge Breland, and I make note with the prior failure to appear in the last 2 years. I think that's inaccurate because I've been with him when we appeared in front of Judge Breland on these 2 4026 matters that are pending about 4 times. So I don't think there's an issue as to his failure to appear or willingness to appear, where he's appeared last month, the month before that, the month before that, the month before that, in front of Judge Breland on both of those 2 matters. That can be verified through Judge Breland's chambers. Like I said, he's 36 years old. 4 persons were in the car with him. Another individual was charged with identical offenses. There's no, like I said, was not on probation. He was not subject to trial release. We don't know how he'll comply with that, not knowing that he wasn't on pretrial release. His prior convictions, I think the last one was 2009, if this is accurate on the CSA and the criminal history. 2009 was his last offense, conviction, I should say, for distribution. That was some 11 years ago. I offer that he's not, no way he could obstruct justice. This investigation has been completed. They have his cell phone that he can't, delete any kind of messages or text or phone calls. Like I said, they have his cell phone. The investigation is complete. He's not a threat to obstruct justice. And it's a danger to the community. He has no violent offenses in the past, and this is not considered a violent offense at this time. So we can't consider him a danger to the community just because he got this charge, standing alone. Even factoring in that he's got 2 pending charges at the same time. Once again, they were written on summons, and he's appeared every time for those matters. That being said, Judge, I asked him to be released with conditions so he can get on the outside and fight this case.
Thank you, Mr. Corby. Any response from the state?
Nothing further, Judge. Actually, I'm sorry, one brief point, Judge. Arguments been raised that the co-defendant in this case was released, so therefore Mr. Means should be. I'd just like to respectfully point out that first, what happens, of course, as the court's aware, we have to look at each individual defendant individually. Mr. Bass, the fact that he was released is irrelevant, particularly because Mr. Bass, off of recollection, had no prior convictions. So that certainly puts him in a different boat than Mr. Means and has no weight or no bearing, and the court should give it no weight here.
All right, thank you. Any final words, Mr. Corby?
I'm sorry, I couldn't hear him, Judge. If you could just repeat the last sentence.
Sure. I argued that the judge should not give any weight to the fact that the co-defendant, Mr. Bass, was released because he has a much lighter criminal history than Mr. Means.
Oh, yeah, I'm not asking him to afford weight to that. I just wanted the court to know that the co-defendant, and the court asked, is the co-defendant, was anyone else in the car charged? Yes, Mr. Wells was.
Mr. Bass.
Mr. Bass, Ramik Bass, I'm sorry,
Yes.
Ramik Bass.
All right, thank you, gentlemen. This is the pretrial detention motion for Mr. Jerron Means. The state has filed a motion for his pretrial detention on both 71 and 78, two warrants that really are the same incident. The court does have a well-grounded suspicion that offenses have been committed. The court therefore finds probable cause. We know that probable cause calls for far less evidence than is needed to convict at trial. At trial, the standard is proof beyond a reasonable doubt. We're not having a trial today, and that will come later. The state will have a much higher burden. In this instance, the court is satisfied from seeing Exhibits S3 and S5, including the preliminary law enforcement incident reports on each, that there is probable cause, and will find probable cause. The court also finds by clear and convincing evidence that there's no amount of monetary bail, non-monetary conditions, or combination of monetary bail and conditions that would reasonably assure this defendant's appearance in court when required, and or the protection of the safety of any other person or the community. That's the primary concern, and or that the defendant would not obstruct or attempt to obstruct the criminal justice process. The court is satisfied from reviewing all the evidence in the case that the state has met its burden of clear and convincing evidence. The court does have a firm belief for a conviction as to the truth of the allegations sought to be established, and the evidence favoring pretrial detention here is so clear, direct, and weighted and convincing as to enable the court to come to a clear conviction without hesitancy as to the truth of the facts at issue. There are many reasons for that, including the nature and circumstances of the offenses charged. Appears to be, and by the way, I have the correct S1, appears to be a total of 14 charges that are drug-related and two handguns. List is too long to fit on this little space that I have for this, but basically the circumstances were this was a traffic stop. Defendant who was driving had two warrants. He was also in the vehicle, was also found 205.4 grams of marijuana, 9.9 grams of cocaine. They were packaged, and two loaded handguns. There were 7 rounds in the large capacity magazine in one of them. It's pointed out, well, there are other people in the car. There's another co-defendant. There can be constructive or joint possession of these items, and this is what Mr. Means is charged with. There are very serious charges, including several second-degree offenses. I should point out that there are 5 second-degree offenses, which each carry state prison 5 to 10 years. The court also considers the weight of the evidence against the defendant, considering the admissibility of any evidence sought to be excluded. That includes the personal observation of the law enforcement officers who investigated, statements of witnesses, including the co-defendant, physical evidence, search warrant results. There was cash, there was CDS, there was 2 loaded weapons, there was a knife, there was a cell phone that was examined, so those contents. So there's lots of physical evidence as well. The history and characteristics of this defendant is an issue that includes his past conduct. He has a criminal history that begins at age 20. He's now 35. This is his 11th arrest. He has four prior violations of probation. That's very significant because 4 prior violations of probation show that he is someone who is not amenable to pretrial monitoring if all the times that of that many times he's been on probation, he has violated probation. He has 7 indictable convictions. So 7 indictable convictions and 4 violations of probation. That's a pretty high percentage. His criminal history is reflected in the Public Safety Assessment NS6, and his record concerning appearance at court proceedings is not a good one as well. The court is most concerned with the nature and seriousness of the danger to any other person or the community that would be posed by the defendant's release. The court specifically finds that he is a danger to continue to distribute dangerous narcotics and other criminal activities while attempting to evade responsibility for those actions. And that'll be fleshed out in a minute. The court, to a lesser extent, but still a concern, is concerned with the nature and seriousness of the risks of obstructing or attempting to obstruct the criminal justice process that would be posed by his release. The court is concerned with potential for witness intimidation of the co-defendant and the passengers in the car, and also based on his numerous aliases and identifiers. The release recommendation of the pretrial services program obtained using a risk assessment instrument is that release is not recommended. The scores are almost maximum 6 and 5. As he stands before the court, this defendant has an outstanding child support warrant from March 12th. He has an outstanding DWI warrant from Delran, January 23rd of 2020. He has a missed operating motor vehicle while license suspended for DWI charge from March 25th, 2019. That's in evidence, notwithstanding the assertions that he's appeared all the other times. He has a missed operating motor vehicle while license suspended for DWI, second or more offense from January 6, 2020. And yet, this is someone charged with second or more offenses of driving while suspended under the influence of, suspended for conviction for being under the influence of DWI. He has an outstanding DWI warrant for a DWI case in Delran. And what is he doing that night? He's operating a motor vehicle. He's driving. There's three other people. There's three other people, and he's...
Judge, if I may, I'm sorry to interrupt. I just want to correct the record. The Delran matter should have been taken care of. We were in court in front of Judge Breland. They arrested my client, brought him in the back of the sheriff's department, contacted Delran, and it was issued in error. I guess it wasn't retracted. I'm sorry. Go ahead.
OR.
Okay, I'll cross that out. Thank you.
And those aren't even my.
Even so, this is a guy who's pending two indictable fourth-degree offenses for driving while license suspended for DWI, and he's driving that night. That is very concerning. It really just shows that he is someone that will just do whatever he wants to do and is not concerned with the consequences of his actions, and that's a danger to the public. He has 7 indictable convictions, 6 are drug-related. Now we have all these drug charges again. 1 is for resisting arrest. He has 5 jail sentences, which is really 1 combined 4-year sentence in 2009. Yet here he's back with criminal activity. 5 total failures to appear, 4 aliases, 3 separate social security numbers, 3 separate dates of birth. And really, if you look at it, none of his prior charges, arrests, convictions, lengthy jail sentence, probation, or parole have none of it has deterred him from continuing to be a danger to others. And the other consideration is that the 2 firearms in the vehicle, which were loaded while possessing drugs to distribute, is an extreme danger to the public, including the 3 other people in the car with him. This could have been a recipe for disaster. There's all kinds of scenarios. Somebody knows he has drugs, they want to rob him. The police get over involved, and there's a tragedy. There's all kinds of scenarios that we know have happened. And is there somebody? Are you saying something, sir? I hope you're not. I already told you not to say anything. All right, Mr. Means, please do not interrupt. We're almost done anyway. The court is therefore satisfied that the state has more than met its burden. This is a dangerous person, drugs, loaded weapons, prior record, missed court dates, aliases. It all adds up to a very large picture here of a person who is not amenable to pretrial monitoring for violations of probation. There's a lots here to guide the court. I'll therefore grant the state's motion, finding the state has met its obligation. I'll direct the defendant be continued to afford a reasonable opportunity for private consultation with counsel. Sir, you have a right to appeal this order within 7 days pursuant to Court Rule 2:9-13. Good luck to you. Thank you, Mr. Corby. And good luck to you, Mr. Means. Thank you, Mr. Almeida. We're going to go off the record.
Thank you, Judge.
Thank you, Judge.
Can I speak to my lawyer? Could you ask him, could I speak to my lawyer?
All right, take care, Judge. Take care, Connie. Be safe.
Go ahead. Sorry.
Oh, you're good.
I had you muted, Brandon. Go ahead.
Yeah, I said take care. Be safe.
All right.
You too, honey.
Thank you. I won't say honey, but thank you, Brandon. Yeah, you're going to get in trouble.
We're not recording.
For what?
I don't know if it was for us talking to Julian's dog or you with the backdrops, but we got an email to remind us that we were live streaming on YouTube.
Oh, I don't care about the backshop.
I don't,
Yeah.
I don't care about the dog either. But
Okay. Who sent you the email?
I guess with Anne Marie and Shannon. But Shannon sent it to everybody. Anne Marie just sent it to me.
All right.
I thought it was funny.
Okay.
Of all the things,
Streaming on YouTube.
because the public should be here. It's not a closed matter. I don't
Okay.
We don't look on YouTube on the weekends, though.
When
Why
we have
can't
a
they
hot
set it up?
flash in court.
Well, the public's
Because
not
this is
here because
12,000
of what's going on. Why? I still don't understand why it's going on.
I don't either.
Guys,
And-
thanks. I have an appointment at 4 o'clock.
Okay, thank you. And of all the things I could have gotten in trouble for saying cute dog is the least of my concern.
Yeah.
But I'm really happy that I said keep them.
Yeah, I know.
It's a good time to cut you off at, right?
Yeah.
I don't understand that.
All right, I don't know if I'm here Monday or not, but I presume somebody will be.
Not
Okay.
looking good, Connie.
What?
I said it's not looking good.
To be here?
Why do you say that?
I feel like we're not. I can feel my bones.
Well,
All right.
everybody's taking their computers
Yeah.
home.
Yeah.
Even
I
people
mean, they
that,
sent everybody but me home.
even people that were out
I
got
have a
told to
weekend.
come in and get their computers. Sherman's wife, they told her, come get a computer. You're the only one left on the third floor?